Sir, we are live now.
Okay. Shall we start, sir?
Yes.
Good afternoon, all. Myself, Dr. M.J. Dhanode, and today we have gathered here through online mode for the workshop on IPR awareness under the National IPR Awareness Mission 2.0, which is organized by IPR Cell of Bharati Vidyapeeth Dr. Patangrao Kadam Mahavidyalaya Sangli under the guidance of Honorable Principal Dr. S.V. Kore sir and convener of today's workshop, Dr. Bharat Balla sir, our Vice Principal, Dr. Amit Suple sir, Amol Wande sir, Varsha Kumbar madam. I am welcome you all the participants. We know that in 2020, our education system has adopted new education policy, and the vision of the new education policy is to transform Indian education system by promoting multidisciplinary education for holistic development. We know that this multidisciplinary approach will help to promote the research and create innovation. So we know that the innovation and research, that is nothing but the intellectual property, and that intellectual property has to be protected, and every person must aware about the intellectual property and their rights. So our honorable principal sir, convener of today's workshop, has done this workshop for understanding of basics of intellectual property for our young budding students, and I very happy to say that we are having esteemed scientist Dr. Niranjan Evle sir, who is working in the National Chemical Laboratory for the today's workshop as a chief guest and speaker. Now I request Dr. Bharat Balla sir to introduce today's speaker, Dr. Niranjan Evle sir.
Thank you, Dhanod sir. Good afternoon, everybody. I am Dr. Bharat Balla, convener of the workshop. First of all, when I use the warm welcome, it's afternoon and really it's warm for all of us. In the afternoon session, we are conducting the IPR workshop on the platform of Dr. Patangrao Kadam Mahavidyalaya. Dr. Patangrao Kadam Mahavidyalaya is a constituent unit of Bharati Vidyapeeth. Our college is having UG, PG and research departments. Thousands of candidates are pursuing their education in our college. And our principal, Dr. Kore sir, is the right authority for taking brief educational account of the progress. But as far as concerned with the present eve, as a convener of the IPR committee, I must disclose the achievement of our college in the IPR. We have about 31 patents, out of which 2 patents we have transferred to the industries. There is a technology transfer. 1 minute. There is a technology transfer with Droplets Innovative Incinerators Private Limited, one of the private limited companies. Second company is also there, that the Dinkar Ayurveda Pharmacy. Interestingly, the patented product, our patented product get exported in 18 different countries. That is useful for HIV infected individuals. No magic remedy claim is there from our side. And the people are using that for increasing immunity, as well as a sort of reverse transcriptase inhibitor activity is also there with our patent. So it's a proud thing for our college to have 2 technology transfers. Another patent what we have is of biological waste incinerator that we have registered at the WIPO, World Intellectual Property Organization, and that has also been commercialized. Our faculty member has bagged the prestigious biotechnology ignition grant of 50 lakh, and definitely in the field of IPR under the guidance of our principal, Dr. Ore sir. Okay, we still wants to do more things. About today's session, already Dr. Dhanawade sir has introduced about the NIPAM, National Intellectual Property Mission 2.0. About the NIPAM that was introduced in the 2021 by Mr. Anurag Jain. The notion of introducing that was to sensitize the educational institutes about the IPR. Preamble was that before 2 decades, about or average 6,000 patents were issued by Indian Patent Office. Indian Patent Office was used to issue only average 6,000 patents per year, and NIPAM has significantly contributed the efforts, and now the figure has reached to the 84,800. I think Dr. Niranjan may correct me, but that is about 84,800 patents. Those have been granted by Indian Patent Office last year. So there is a significant contribution of NIPAM activity. Though many research scholars have joined the webinar, the prime notion of the NIPAM activity is to sensitize the students of higher education so that from beginning only those should know about the intellectual property. What exactly is the intellectual property? Those are doing their small projects under, as Dr. Dhanawade told us, the new education policy has expected the um laboratory work, small projects, then industrial visits. Okay, during the laboratory work, if a particular student finds a innovation, that innovation can be converted into patent. And for inculcating such principles among the students, NIPAM was introduced by Government of India in 2021. And fortunately, we got the nice team. India got the nice team of NIPAM when the number of attendees exceeded above 600. Today, the number is around 624 participants have registered for the eve. Then the NIPAM team has decided to give the best speaker for our webinar, and that is the reason why Dr. Niranjan is here. About Dr. Niranjan, he is a senior scientist, well-known senior scientist at CSR NCL. He is the member of Intellectual Property Group of Government of India. He is engaged with the IP portfolio, technology innovation, and NIPAM activities. He is qualified patent agent. He provides advice on the technology transfers, IP registrations, and its commercialization. He completed his PhD in the polymer chemistry and later postgraduate diploma in intellectual property rights. He is the awardee of prestigious Dr. D.S. Kotari postdoctoral fellowship. He also has industrial experience for securing IPR at Udaipur and Hyderabad. So, with this brief introduction, as the NIPAM has introduced Dr. Niranjan as the best speaker for us, and deliberately, and that is not an accidental event. Deliberately, now the team has sent Dr. Niranjan here. So 626 participants are there, Dr. Niranjan sir, and we are expecting uh, 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 the concept of IPR, what notion is there of NIPAM, accordingly, what you want to deliver to we people, to our students. Okay, I request you to deliver your speech. Thank you, sir.
Thank you very
Thank you,
much.
sir. Thank you, sir,
Uh,
for such a brief
one minute.
introduction of today's
Sir,
speaker.
1 minute. Dr. Dhanawade, sir.
Okay. Yes, sir.
Yes. Dr. Dhanawade, sir, please
If I am
proceed.
audible, yes, yes. Okay. Thank you, Dr. Balla sir, for such a brief introduction of today's speaker, Dr. Niranjan Hevale sir. Now I request our respected principal, Dr. S.V. Pore sir, to do the welcome and forward. Dr. S.V. Pore sir.
Honorable Head, Intellectual Property Department and Principal Scientist, CSIR NCL, Dr. Niranjan Yole, the convener of this today's event, my colleague, Dr. B.B. Balla sir, who is the convener of IPR cell at our college, Dr. Mrs. Varsha Kumbar, member of IPR cell and head Department of Zoology, and Dr. Maruti Danaude, a colleague from Department of Microbiology. It gives me a great pleasure to have been associated with you in this a national event. I am proud to say that more than 500 participants have joined this event. So, as a principal of this college, I welcome all you. And I want to just introduce my institute, Bharati Vidyapit, which is one of the leading educational institutions in India, founded by a great visionary, Honorable Dr. Patangrauji Kadam Sahib. Bharati Vidyapit Pune was established in 1964. As a result of this and sadness and determined efforts within a short span of the year, under his dynamic and visionary leadership, Bharati Vidyapit has taken huge strides in the field of education. It has more than 180 educational branches, imparting education from the pre-primary to the postgraduate level. It stands dignified, imparting education in a wide array of disciplines like medicine, engineering, pharmacy, agriculture, architecture, law, management, fine arts, bioscience, biotechnology, environmental science, art, science, and commerce, etc. To make education available to the deprived and backward, a large number of schools have been also set up in rural as well as urban areas. Bharati Vidyapit was founded with the sole objective of making education available to desired. It is one of the very few multidisciplinary deemed universities of our country. Bharati Vidyapit has commendable contribution toward the empowerment of women, the needy, and the rural youth. The motto of Bharati Vidyapit is social transformation through dynamic education. Our college, Dr. Patangarao Kadam Mahavidyalaya, was established on 16th September 1985 as a Art, Science and Commerce College at Sangli. And it was renamed after Dr. Patangarao Kadam Mahavidyalaya Sangli on 8th January 1919. The college has a spacious and beautiful building with well-equipped laboratories, classrooms, ICT-enabled classrooms, auditorium, two open stages, landscape garden, and a playground. This is the only college in the city which imparts education in the faculties of Arts, Science, Commerce, Junior College, and HSC Vocational also. At the end of this, I announce the next event of our college will be at international level. With this, I conclude my speech. Thank you. Thank you very much.
Thank you, sir, for your encouragement and support. Now I request our today's guest speaker, Dr. Niranjan Evle sir, to start his presentation. Dr. Evle sir.
Yeah, thank you very much. Uh, just confirm I'm loud, clear, and visible. I will share my
Yes, sir.
screen. Yeah. So already the ground has been set by Dr. Ballal effectively, so that there are filings from institute as well. Please confirm my slide deck is visible and it's moving.
Yes, sir. Yes, your slides are moving. Please proceed.
Okay, thank you very much. So today we'll be understanding regarding intellectual property. Before understanding intellectual property, the first query comes in: why intellectual property matters? So we need to understand the context, why it is so important in today's world. So one of the case study, if we see, over the period of time from 1970 onward, 75 onwards till recently, 2018, this is a chart of S&P 500. It's kind of a stock market in US, so similar to Sensex in India. So in 1975, if you see that comparison between the intangible asset and the tangible asset, the difference between both of them is the tangible assets which you can see or the feel, like our home, properties, etc. Whereas the intangible asset which are created through your knowledge. So if you see the progression from 1975, the intangible asset is having a more and more contribution, and in future it will be more. The reason being, because there is a limitation to generate the tangible asset, right? You cannot grow land. However, in context of intangible asset, your knowledge can be extrapolated, not limited only to the Indian jurisdiction, but it can be considered for foreign jurisdiction as well. So you can get protection, you can get the monetary gain by protecting it in foreign jurisdiction. So if you see even the companies which were focused earlier in 1975, IBM, ExxonMobil, Procter P&G, GE, 3M, they were manufacturing companies. And if you see in the 2018, all are digital asset companies like Apple, Alphabet, Microsoft, Amazon, Facebook, being they are focusing towards protecting their IP. So through the brand building, etc. So there are multiple aspects. So this is a pictorial scenario for all of you, that there is really very important to understand the IP context and to secure our intellectual property. So now you understood that why IP matters. Now we'll go into the different types of intellectual properties. So these are very preliminary slides. We will deep dive into each of the aspect in the latter slide. So patents are there. Legal right, that is for new invention. Whatever the new inventions are there, that can be protected under the patents regime. And how it can be done? Through application followed by examination. It is for the product or process, whatever you develop something which is innovative, that can be protected through patents. There is another legal right, that's in utility models. This aspect is not at all there in the India. But few of the European countries and other rest of the countries also do have this utility model concept. That is also for new invention, and the process is how to get that utility model. It's from the application followed by registration. You can understand the differentiate between the examination and registration. So it's for the new inventions only. However, we'll deep dive when we go into the patent section. What are the criteria? There are novelty, inventive step, and utility. So the moment you have the novelty aspect, you can get the utility model. However, for patenting rights, you need to understand the inventive step also. We will go when we study the case study, different between this criteria. The next legal right is about the copyright. It is for the original creation or the artistic forms. And the moment you create the right get exists automatically. So you don't have to register it anywhere. However, for any future litigation, it is appropriate to have a registration in place so that you can defend your case appropriately in court of law. The next legal right is trademarks. It is for the distinctive identification of product or services. The product is coming from which particular company, you connect through trademarks. And the process how to get it is through the use and or registration. Again, here is also the option of through direct use also you can have the trademark, but it's really important to get it registered. So similar to the copyright, it will be having where if you are going into the court of law, this registration will really help your cause. The next aspect is register design. It is for the external appearance, and the process is through the registration. Whatever this bottle, if you see, the examination is done through only visualization. So there is no technical aspect involved. Only the visual difference has to be there for the register design. The next legal right is trade secret. It is the valuable information which is not available to the public. So it is very confidential between selective people. Even in the organization, it is not known to all the employees. It is limited to very selected people, wherein you have agreement with them that they will not disclose or talk with anyone else. See, if I have to give the example for the trade secret, the Coca-Cola recipe, the juice, that's been considered for the trade secret, and they are extrapolating after century also. So you can understand they have kept very reasonable effort to keep it within few selected people. So if the example has to be explored, within the Coca-Cola, only 2 to 3 people knows those ingredients, and those 2 to 3 people doesn't know the full information. Only if assume that A, B, C are the content. A is known to the first person, B is known to the second person, and C is known to the third person. However, this ABC context is not available, and within this first person, second person, third person doesn't know who other persons are. So that much of reasonable effort have been kept by the Coca-Cola to keep it secret. One product can have multiple IPs. The example being this Nokia mobile phone. So the IP involved here is a trademark. The Nokia terms itself has been protected, followed by this product 208 and the startup tone. The tone was very unique in a Nokia context, so that is also been covered under the trademark registration. Followed by this copyright. So the software involved in this mobile phone and the user manual which you receive along with the mobile, that is being protected under copyright, so that content cannot be reproduced without the confirmation from the Nokia. So that much of secrecy, not secrecy as such, that much of content they have protected. The ringtone, startup tone, images, these all are being considered for the copyright protection. In patent and utility models, the data processing methods are present in the mobile, and the operating system which is there in this mobile system, and the operation of user interface, how that particular app will be working on. So these all aspects can be covered under patents and utility models. How that particular phone appear, the form of overall phone, arrangement and shape of button, position and the shape of screen. So the distinguish is like you can judge, though you can differentiate between the other Nokia phone and that particular 208 model. So you can get if you can distinguish the design registration. And trade secret, some technical know-how which is kept in-house and not disclosed to public. So you can understand that these all multiple IPs are involved in only single product. The similar examples of valuable intellectual property like Coca-Cola, Apple, Harry Potter, and this instant camera from the Polaroid. In Coca-Cola context, I gave the example of trade secret, but if you see the can, that can be considered under the design registration. A few of the other aspects which Coca-Cola feels that can be covered under the patent. The difference between the patent and the trade secret is like patent, if some invention is there, you have to disclose it to the public, so that after the validity of 20 years, that can be exploited by any normal public also. That is the reason the patenting monopoly is given for 20 years, followed by it is free for public use. So this aspect, if you Coca-Cola feels, that aspect can be considered under the patent regime. And if you see that Harry Potter book series, right, the J.K. Rowling, the author, has protected it under the copyright, and she has not limited only to the novel series. She got the monetary benefit when the movies were made. So she earned not only through the books but also through the movie. That is the power of intellectual property. Now we'll deep dive into the patenting aspect, importance of patenting. If you could see this particular chart, that is for the Humira patent application filings. So over the period of time, you can see that from 2003. However, this particular product was developed in 90s. So the work was carried out, but they had an IP filings till recently, 2015. How they have done? They have not limited. Earlier, it was only for rheumatoid arthritis, but it was extrapolated to for the other diseases. And this particular molecule has been developed it's a collaborative work between the BSF and the Cambridge. Later on, Abbott Laboratory purchased this Null Pharmaceuticals, which was a BSF part, at the cost of 7 billion in 2000, 7 billion US dollars. So if you understand through this chart that there are filings still continuing, and this is what the patenting strategy is. So you know that there is a validity of 20 years for the patenting, but it has been extrapolated to almost like 32 years if you calculate all together. So that is for the other applications. So in terms of the monetary, if you calculate, so even that full company was been at the cost of 7 billion approximately, but it is having a best selling molecule. So the cost is almost like 3 times only in the single year. So you can understand why they could extract that much of revenue, because of they have done monopoly through these particular IP filings around it. Now we will have another example. This IMAC is a leading public research institute. It's headquartered in Belgium, and even in Bangalore they have their unit. And what they do, they provide an ecosystem in nanoelectronics technology, and they work in multi-party research collaborations. So if you see, in 1984, they had a revenue of 6.5 million euros, which was grown almost multifold to 300 euro a million. So you can understand that there is a huge shift in terms of revenue. So in 1984, the 90% of the operating cost was through the public grant, whereas in 2011 they have to spend get only 15% through the public grant, and rest they could manage on their own. How they did it? They did it through this industry affiliation program. So the industry got collaborated. So this all the operating costs they can generate through that collaboration. So they have almost like 4,000 plus workforce from different nationalities. They collaborate with almost so many universities, wherein the PhD students get an academic-like environment, access to funds, and a state-of-art infrastructure because of the industry collaboration. So why industry come to them? Because IMAC does protect few of the PhD thesis selectively, wherein which can be beneficial to attract these industry partners. So it's like a background IP on that future IPs they can develop. So industry get the confidence. Okay, IMAC has been very IP friendly. So if we invest in this organization through that collaboration, so that they can get the return of investment. So as I mentioned, it's like a background knowledge so that they can generate the future IP around that particular research work. Who needs patent information? So in today's world, each one of us need to have patenting information. For example, the R&D professional. If the person working in the industry is as an R&D professional, he's managing his project. Let's assume he doesn't have the background. So what he will be in the mess up? So he will not aware of this patenting aspect, and if the work is been not aware, and he will be just simply redoing it, which has been already protected by someone. And in industry, they will not have that much of liberty, that like timeline and resources. They will have a calculation of each penny they invest. So they wanted to make sure that whatever the work is being done, it is kind of an inventive, so that they can have an return of investment whatever they do in terms of time and resources. Similarly, the entrepreneur, for him, similar to the R&D professional, entrepreneur also need to have patent information, because if you wanted to launch any product, and he need to have a freedom to operate before launching any product. So from where that particular information will come, that is through the patenting information. So as to avoid any future complexity, assume that he was done his homework and he came across, okay, there isn't some IP has been protected by XYZ company. So either he can stop, he can redesign his product, or else he can have a collaboration. That's will be win-win situation for both the parties. So it depends on how the other party takes into consideration. So entrepreneur also need to have this patenting information for effective strategy. Business professional, we can consider that IP professional, considering myself. So we need to have this patenting information for strategizing any project, or how we have to go ahead. So to avoid any complexity, or to have an background information that which company is working in that particular domain. So such kind of an information will get through patenting information. Public policy maker also need to have patenting information, because if they know what kind of an IP is coming out, they can design the policy effectively. Let's consider in health sector during pandemic. We all know India and South Africa took lead to ask for the IP waiver, wherein that it will solve the social issues that COVID related. Patenting can be have an IP waiver. So what are the benefit of patenting information? It's like protecting yours or company's investment for development of invention, for perfecting it helps to avoid duplicating research. So you don't have to redo the things if something is already there in the patent literature. And if some solution is there, you come up with better solution to that, solve that particular problem. So from how you can do that, that will be done through the patent information. The patent application do get published, and it helps to avoid any infringement because of someone else earlier filing. So the publish is also one of the benefit of patent information. Planning, as I mentioned, in terms of business professional, so this business planning decision on licensing, tech partnership, merger and acquisition can be get through this patenting information. Also, to monitor the research activities of competitor can be carried out through this patenting information. Now let's understand the patent basics. What are the requirement through this one of the case study? Braille code, I think each one of know that code is being used by visually impaired people for reading, writing, and see each alphabet having different representation. A is having a single dot, B. So there is a unique representation through the dots. So who has developed it? The Louis Braille in Paris. He has developed in 1809. So at very young age of 3, he lost his eyesight, and so during that period of time, the raised print kind of like an embossing, that kind of methods were available during that period of time. And in 1821, one Captain Charles Barbier, who used to communicate to the soldier through this dark night writing raised dot method. But this whatever the night writing method was there, it is based on the sound notation. So so that kind of an information Braille got, and he designed the technology that will be helpful for the normal people who are visually impaired. So and he has an system of dot based on the alphabet. The Charles Barbier method was based on the sound notation. So he really worked hard to achieve whatever the target he has set, and he had very new and very different idea. So Captain Barbier's night writing method was based on sound, whereas Louis' method based on alphabet. So there is a differentiators, right? And similar to the French, English means both of them have a 26 letter. So he invented a means of literacy for blind people. He continued for several years, developed separate code for numbers as well as musical notes. He published his first book in 1807, and he couldn't see the fate of his whatever the system he has developed. He passed away very at the age of 43 only because of tuberculosis, and he could have seen that how his system has been widely adopted by each visually impaired peoples. In context of modern patent law, that's Paris Convention, which was initially signed in 1883. So you can understand to the country year comparison also. So this modern patent law came into this as an existence after he passed away. So there is no as such IP protected, but the criteria which are required for patenting can be satisfied this Braille code by also. So he worked hard and to achieve this successful development. He had a great open mind. So he got the idea regarding that sound communication between the soldiers, and he had a very perseverance to find and test a solution. And he kept on experimenting. And because of this diligence and awareness and need to invent a system for reading and writing for the blind people, he could achieve. And ultimately it gave independence to blind people. Now we'll understand the what are the criteria for patenting, right? So it can be very complex. Invention can be very complex like a robot, but it also can be simple as a paperclip. However, it has to satisfy this criteria. The first one being industrial applicability. So this system was not only a brilliant idea. So because of his hard work, he could make a product system of dots, which is being used by blind people for reading, writing, and printing book. So the utility criteria has been satisfied. Other important aspect or the criteria required for patenting is novelty. So whatever the invention you develop, it should have a new characteristic than the current knowledge during when you are inventing. So earlier people had tried many things, like as I mentioned about the embossing, so raised dot, lower dots, letter of stone, letter of string, letter of wax, letter of wood. Even one man tried alphabet of pins, and this Captain Barbier's night writing method was based on sound notation. However, Braille method was on the letter of alphabets. So the most complex among all the criteria is inventive step. Right? That means non-obviousness, meaning that the new characteristic of invention could not easily be deduced by a person. So it's like it should not only have a new characteristic, but it cannot be made by the normal, whatever the subject expert in those domains. They cannot simply combine those aspects. So in context of Braille code, so the earlier methods were like raised dot, lower dot, letter of stone. So the letter of stone, there is a very challenging scenario, right? If you have to write or this, you need to carry the stones, letter of strings, even the letter of wax. In terms of wax, in summer you cannot use it because the wax will get melt, and wood also has its own problem. And but the person who tried with the alphabet of pin, see, we are developing a technique for blind people, and the alphabet of pin, it will be very hazardous for the blind people, right? So, and even in if you compare that Captain Barbier's, it's for the sound context, right? The sound, and before means before learning that technique, blind people need to learn the sound music's notation. So that is very challenging. So because of that, no, this no, blind people very got connected, and it could generate, it could satisfy this inventive stage, because there are multiple problems associated with the whatever the inventions available during that time. So you can establish inventive state by justifying their challenges associated to the earlier art available. And other than these three, there is a statutory requirement. It varies from country to country. So so we'll go into that in the latter slide also. So this is what the patenting aspect we have learned, that it should have a novelty, inventive step, utility, as well as statutory requirement. However, that's application, it's a national application. Let's say example in Indian context, if you have to file an invention, you file through the national application. And if you wanted to go abroad, so let's assume that international application, there are two ways: through the Paris Convention or the PCT, Patent Cooperation Treaty. So if you are following this Paris Convention, if you are filing today in India, within 12 months of time, you need to go into the entering into the different jurisdiction. So you get 12 months time to enter into the foreign jurisdiction. However, if you follow the PCT route, if you file today in India, within 12 months of time, you need to file this international application, PCT application, and you get this extra 18 months period of time if you follow the PCT route. And what are the cost involved for the translation, official fees, local agent, that shifted by 18 months if you follow the PCT route. Having said this, if you are very sure that there is a very limited IP filing you have to follow, that for example in US or Europe, you can directly go in this time, avoiding this whatever the cost involved for this international application. The benefit of another this route for this PCT application is you get an search report and written opinion. So we understood, right, whatever the criteria. So this international search report and written opinion will give you the idea whether your invention is patentable or not. And to attract other collaborative parties, this will be really helpful if you could find that okay, that this is kind of an exhaustive, because before filing also you do your homework, that patentability, whether your filing do have an inventive aspect, yes or no. Similarly, this will be kind of a document to attract other collaborative partners. So if you see this patent life cycle, it's kind of similar to most of the jurisdiction, but there will be slight changes. Now we'll go into the Indian context. The slide is very heavy, so we'll go step by step. Filing of patent application has been done, can be done through the two ways. You can file direct complete specification. The complete specification means whatever the information or whatever the scope, everything is been covered in the patent complete specification, including claims. The boundary is generally what we do in property, the Satbara, right? So in this context, in patenting, you need to have a claims. Whatever the invention you have, you need to claim it appropriately. So if you are following the complete specification, So it will get published within 18 months of time. If there is another route, if you go with the provisional specification, you need to file complete specification within 12 months from the provisional specification. If you do so, that you file this complete specification after provisional, your application will get published from the date of provisional specification. So this 18 months will calculate it from here. If you don't file your complete specification after this step, your application deemed to be abandoned. So there is no active IP on your name. So after publication of application, then if some other party come to know, okay, so they can file this pre-grant opposition, that they can challenge, okay, this has been already there in the public domain. There are so many criteria associated, they can challenge to that particular filing. Meanwhile, after your publication, you need to request for examination within 31 months. So you can do it at the time of filing also, so that everything get expedited if you do this request for examination at the. However, that should be done within 31 months. If you don't file request of examination within 31 months from the date of priority, your application deemed to be abandoned. So let's say if you have filed a request for examination, and that examiner, what he will do, he will go through that whatever the criteria we understood in the earlier slide, and the statutory requirement, that's a requirement based on the country to country laws. In Indian context, if you see that there are multiple non-patentable subject matter from so many aspects, means chapter 3 and 4 are very dedicated that what is not patentable subject matter. And even the defense related stuff you cannot patent. So it varies country to country. And once this examination is done, FER, first examination report, has been issued, and you need to reply to those objections within 6 months of time. And if examiner is not satisfied, he will give one-time opportunity for one-on-one hearing. So you will have to defend your case one-to-one with the examiner. If objections were not overcome, so whatever the objections were raised and those were not satisfied, your application deemed to be abandoned. If those objections were overcome, so examiner is satisfied whatever you are saying, he agreed with that, so your application gets into grant of patent. After grant of patent, your job is not over, so you need to maintain that filing. So you need to keep that filing to have an IP protected, so by paying annual maintenance fee. Yeah, so now patenting aspect has been done. Now we'll go into the design aspect. It is for the ornamental or aesthetic aspect of an article. As I mentioned, it's not a technical aspect, it has been aesthetic aspect of the product. So that's a feature of shape, configuration, pattern, ornament, or composition of line or colors applied to any article, whether in 2D or 3D or in both forms, by any industrial process. How you can do it? Through the industrial process or means that can be manual, mechanical, or chemical, separate or in combination. And whatever the finished article is, it will be judged solely by eye. So you need to distinguish by seeing those product by only eyes. So there is no technical aspect involved. So these are the example. See here, so many bottles are there, but each one of them have a different configuration or the pattern. So you can get design registration for each and every bottle. In patenting context, so the novelty you can object, the inventive step which we mentioned, no, you need to give the advancement over other aspects. So herein, if you can judge solely by eyes, okay, this is different bottles, so you can get the design registration. So these are all other example wherein you can easily differentiate each of the product. In trademark context, it can be any word, name, symbol, or device, or their combination, and it identifies and distinguishes the source of goods or services from one trader from those of others. So let's say take the example of mobile. You can distinguish easily Apple phone or Samsung without entering into it by simply seeing the trademark associated with those products. So you can connect to the company by this trademark. That's a simple answer I can suggest. And it provides exclusive monopoly over the class of goods or services. It allows business entity to build public goodwill and a brand reputation, and it identifies the source of origin of goods or services. So you connect from where this particular product is coming out, and it assures customers about the quality of goods or services. So these are all the subject matter associated with the trademark: trade name, collective mark, certification mark, tagline, slogans, shape. What is a good trademark? It need to have a distinctiveness by inherence, means that particular trademark should have an inherent characteristic of differentiator, as well as the acquired, whatever the you give. For example, this ye dil mange more, you can connect, okay, it is distinguishing, there is no similar kind of instruction trademarks available. So distinctiveness should come up whenever the trademarks are being filed, and it should not be deceptively similar. It should be honestly adopted or coined. It should not be similar to already existing mark. And before adopting any new mark, it is very advisable, like we did in the patenting aspect also, you need to understand the criteria. So once you are you have done your homework, you can get a confidence, okay, my trademark is nowhere related to any deceptively similar trademark. So if any product mentions about the TM, that means the application is pending, and if it is R circle, that means the registration is already been done, and it is now protected, that particular trademark. So that registration is optional, as I already mentioned. It can be done through the use or the registration, but it does have, registration does have several benefits. I mentioned about the scenario wherein if there is any case going on in court of law, registration will really help to put forth your case. The registration can be done at national, regional, and international level. So the validity, if you see that it is for initial 10 years, however, it can be renewed indefinitely. So there is no timeline you can stop. After every 10 years, you need to renew it to keep that particular trademark live. And if you are not using it, not renewing it, or there is no policing on your that particular trademark, your rights will get lost. So though there will be no trademark protection available if you are not following these three criteria. So the copyright, it's a bundle of right. As I mentioned, it's an automatic right. The moment you create it, automatically it gets. But it's appropriate, you get the registration done to have an. It gives you the opportunity to choose the way your copyright work are made available to the public. So as I give the example earlier in J.K. Rowling Harry Potter series, she made it available through the novels, and she also given license to the movie makers. So she prevented unauthorized copying and reproduction. So that is the reason she got this too much of monetary gain through this multi IP involvement. So what are the criteria for the work to be copyrighted? It should have an creativity, it should have an originality, and the fixation. Fixation means in case of J.K. Rowling, the novel, the book, right? The medium is been fixed on the paper. And if the movies, it will be like a digital transformation. So that medium has to be fixed to achieve copyrighted protection. So these are all the subject matter associated with the copyright: literary work, dramatic work, sound recording work, artistic, musical, and cinematographic films. These are all subject matter that can be protected under copyright. SICLD, semiconductor integrated circuits layout design. This is one of the, for fast changing technologies like electronic gadgets and computer, this protection is available, wherein you can have those connection, the layout connection protected under this IP regime. This office is based in Delhi, and if it is for, as I mentioned, it is for the fast changing technologies, and the registration is done for the initially 10 years from the date of application of filing or first commercial exploitation, whichever is earlier. I will not go into the detail. It's for the electronic and IT related SICLD processing, and there are other fees involved. Geographical indication, so it will be kind of similar to the trademark. So once we explain it, you have to connect between those two. So in trademark, we understood from where that particular product is coming. That means the company, right? However, in geographical indication, so the product that have a specific geographical origin and possesses the qualities or reputation that are due to that origin. Here, the differentiator is in trademark, it is a company, and here in geographical indication, it's a geographical origin. And because of that geographical origin, it has a certain qualities, right? Let's say assume this example of Darjeeling tea. The Darjeeling climate, soil condition, environment has a specific characteristic to have that particular tea. So whenever this particular tea is being sold off, if it is coming from Darjeeling, GI, so customer get connected to the Darjeeling tea through this GI tag. And in context of a trademark, it has to be the person is like a company. Here it's a community that what particular full area can consider to have an geographical indication. So not only limited to the soil or environment condition, also to the artistic artists present in those areas. For example, this Suraj Zari craft, it is because of the craftsmanship available in that area. So how they make it, so that waving pattern. So this knowledge has been transferred from one to another generation, and these artists are present in the specific jurisdiction. So you connect through that particular origin if you see this particular GI tag. So these are the example of Darjeeling tea, Makrana marble, Ratlami sev, Kachipuram seal. These are other agricultural product which were considered for GI registration. Now, if you have to summarize the validity, the patenting is for 20 years, and there is nothing called global or international patent. And design is for the 10 years first. You can renew it by an additional 5 years. Trademark indefinitely, provided you do this renewal in time. GI is similar to the trademark. It has also indefinitely subject to renewal. Copyright, a lifetime of author plus 60 years. So that much of time you can exploit whatever the IP rights you have. Here, who can apply? A person can apply or legal representative. However, in GI, as I mentioned, it has to be community, not any person per se. And all IP rights are territorial in nature. If you wanted to exploit in other country, you need to have IP protected in those country, US or EP. You should protect your IP in those country also if you wanted to exploit there. Point to remember: first protect and then publish. Rights are territorial. Registration is done by the sovereign authority. Rights for limited period of time. We saw in the earlier slide about the validity. There is no automatic relief. If someone is copying your IP, you need to file an infringement suit. Until and unless you don't do it, you cannot get the remedy over it. So you need to stop others for copying your invention or IP. Renewal fees to be paid for some IPRs, the exception being copyright and trade secret, because the trade secret you don't protect anywhere, you keep it within yourself, so there is no fee involved. And for filing any patent application, you don't need any patent agent. There is no compulsion. As an inventor or applicant, you can do on your own. So if you see the career opportunities, there are like government job, like examiner being a patent agent, patents and design, also for the trademark and GI, copyright. These are all government related jobs present in this domain. And others being the patent agent. If you are qualified as a patent agent, you can exploit, means you can help others to file their invention. So ultimately, you can have a career opportunity in that sense. Similarly, the JRF, SRF as in patent facilitation centers, patent litigation and other opportunities in private sector means law firm. Even in the private industry, there are multiple opportunities. If let's say assume any chemical company is also there, so they will need to have such kind of an IP professional also. Now, I will need organizers support. There is a quiz, so participant have to answer over here, because my screen is entirely I cannot see the comment section also. So if organizer can help me, so that will be really helpful. So this is what the one box is there, wherein multiple trademarks are been mentioned. So
Sir,
participant can identify what are those. At least 10 trademarks are there. If participants are answering, you need to help me. Is there are any answers?
कमेंट घ्यायला लागेल. कमेंट टाईप करा म्हणून सांगा. किती शो करू. तुमची कॅमेरा हे चालू करू.
Yeah.
Hello.
Any answers?
Participants,
Yes.
please type the comments.
थांबा सर, तुम्ही नाही ह्याच्यावर अजून. हा सांगा सर.
Participants, please type the comments so that organizers can see and can retort to you.
So the
Please type in the chat
product
box.
you can find out over here. At least 10 trademarks are there. If you find out 5, then I can understand you understood the context of trademarks. I'll give the example. I think cursor is also visible to all, right?
No sir. Yes sir. Yes.
So any answers other than Amul? It's like Sudoku. You need to give stress to your brain to find
Tata.
out those words.
Swapnil Gaikwad. Sohla Pepsi.
Very good. Pepsi is there. Yes.
Okay, what do you mean?
Any other answer?
Dettol. PRQ.
Very good.
Dr. Sujata Patil. Not at retort. Bamboo.
Yeah. So there are multiple trademarks. It's like on Amul, Tata, Dettol, Babool, Bata, Horlicks, Cadbury, Ling, Pepsi. Now you need to answer. You need to find out IP involved in this picture. In first picture, Mona Lisa, what kind of an IP can be considered for protection? It's an artistic form, right? So what will be the answer? There is an creativity, originality, and
Please type in the chat box, audience.
so it has been fixed on that sheet, drawing sheet. So the fixation is there already. There, originality is there, creativity is there. Even the second picture follows the same. This sculpture. Which
Copyright.
IP can be yes, good, right? It's right answer. Copyright. So that there is an creativeness over here, right? So artistic things are over there. How about third picture? We already saw Nokia thing. We saw the example of Nokia. Now here that in context of Apple, this bited apple, what are IPs involved in these particular products?
Design from one participant.
Yes, design is one of them because we saw multiple IPs can be considered for one product, right? So not only design, it can have whatever the operating systems are there inside, user interface that can be considered under the patent regime. So there are multiple IPs involved in third picture. Patent, design. You can see this trademark, that bited apple that is been protected under trademark. It's a symbol, right? And you connect by seeing this bited apple to the company. So even the fifth picture will have, so how about the fifth one? This Coca-Cola bottle. What IPs can be considered?
put in the chat box. I will read your chat. Font calligraphy. Okay, second. Logo from Samruddhi Patil.
Yeah, so the logo, it will be under trademark. What are the logos, names, the combination?
Another is design
Yes, the
from
bottle
ARK Ball.
design. Very good. Even the syrup also
Product
at the
patent.
bottom you can see that syrup is there. So that can be considered under a trade secret. So multiple IPs are involved over here also.
Yeah,
How
Javed sir.
about the fourth one? Fourth is only single answer. You need to answer only one. Bisleri, which IP? The name itself is there only. So there is no other thing which you can visualize over here. Bisleri is which IP is involved here?
Please type logo. Logo.
Yeah, so it's a logo. You need to connect that logo goes into trademark. So IP is trademark, not the logo, because there are multiple things. Logo can be there. There can be
Akshi trademark.
shapes. So it will. The answer is trademark. Now, which type of IP protect the painting painted by artists? You have given in earlier example 1 and 2 the answers. So just is kind of an real means you for remembering that's another one time I asked. So the painting painted by artists can be protected under which IP? There is an
Please type. I
original.
will read. With no additions, I will read. Please type. Give response because that will be recorded at government office.
So, likewise to the first two example in the earlier slide, it will be considered for the copyright. What protects the intellectual property created by fashion designers? Now there is a complexity. Fashion designers can have an artistic form as well as the design. So there is a multiple IP again. Copyright designs can be considered. What protects the advanced disc brake for bike developed by the inventors? So what will be the exact answer? The correct answer will be, because the moment inventors, invention, inventiveness comes in, the answer will be,
Yeah, it's an innovation. So please answer. Please type in the chat box.
so we understood the context of criterias also, right? What are the criterias required for XYZ inventions? So what kind of an IP?
Specifically, UG students who have attended, please try for that. That might be right or wrong.
Yeah, if wrong is there, you can correct it now itself. So the patenting aspect, right? Whatever the advanced display break is made for the bike, and inventor terminology is there, it gives direct answer that patents. Uh, Now this will I will wait for this answer. Which of these is a geographical indication? I will need at least 3-4 answers before going ahead. I mentioned about the geographical origin. It should have geographical term in the GI tag.
Yes, Nagpur orange from
Good.
BPKM Sangli.
Yes. So the whatever the GI tags are there, it's so you will find out the location plays as well. So the Nagpur orange is the right answer. What does the trademark protect? So in earlier slides, multiple times I heard the name in this context. So the here the answering will be very easy. So what does a trademark protect?
Please type. I am reading.
So in Bisleri also
Logos,
you
names, and
someone gave
brands.
answer.
Okay.
Yeah, it should be logos, names, and brands. Others where an invention is like patent, a work of art goes to the copyright, a secret formula goes to the trade secret. Okay, so the trademark protection is through the logos, names, and brands. How long patent last? So the validity, how much years patenting can be exploited?
Please type in the chat box. 20 years.
Good. So answer is 20 years. If you write an original story, what type of IP gives you the right to decide who can make and sell copies of your work? You connect to the JK Rowling. What will be the answer?
Okay, chat box. Copyright.
Yes, copyright. So JK Rowling can decide which way her copies will go. Even she can decide these movie
Sunil Lakram,
makers
sir.
to make
Okay.
movies.
Thank you, sir.
Yeah. So now imagine a cricketer
No, madam. Thank you.
through
Vaishali,
whom
thank you.
you follow sets up his own company to sell his own range of clothes. What type of IP can he use to show that the clothes are made by his company? So whatever the product is there, if someone is cricketer sets up his company, so it has to connect it to his company. Through which IP you can connect? So Apple product is there. How you understand that is through this that bited apple symbol. If you see, you connect the apple. That is what it's an trademark, right? So any person sets up his company. If you wanted to
Trademark.
connect,
Mangesh Gavit, sir. Okay.
yeah. So it is the
Yeah.
answer is trademark. It's like to the earlier one of the question. If a company develops a new technology that improves its main product, what type of IP
Thank you,
can
Archana,
they
madam.
use to stop others from copying their invention? So it's very easy. We followed earlier also the disc brake related stuff. Again, inventors were there. Here the invention. So the technology has been improved to make the product. So again, the answer remains
Patent.
patents.
Poonam Panaskar. Okay.
Yeah, that's it from my side. Uh, I will be happy to answer if anyone has a query.
If you have the questions, please type in the chat box.
So just out of curiosity, it was live. So is there any means that may be the reason for the delaying reply? I don't know if it is.
No, sir. They are interacting with comments. We will make available comments on
Okay,
our.
okay, okay,
If anyone asks the question, I will display on the board.
okay.
Sir, camera चालू करतो. Yes.
Any questions? So request to the audience, I will share the mail ID of sir. Even if you
Yes,
raise the questions later, you may communicate with the Dr. Niranjan sir if you want. Yeah,
yes.
yeah, yeah.
Yeah, definitely I will answer those.
Kumbhar madam?
So you can share that link to each one of them, so
Yeah,
that
yeah,
that
yeah.
will be kind of recorded for their attendance, and the correct information has to be filled up.
आले.
Yeah. Hmm.
Yeah.
Kumar madam?
Yes, sir. Sir,
Yeah. Can you proceed,
am
please?
I audible?
Yeah. You are audible, ma'am.
So now I request Dr. Varsha Kumbhar madam to give vote of thanks for this workshop. Dr. Varsha Kumbhar madam.
Thank you, sir. Am I audible,
Great
sir?
question. Okay.
Yes, yes, you are audible, ma'am.
Okay, thank you. Good afternoon, everyone. I am Dr. Varsha Kumbar. As we have come to the conclusion of this enlightening workshop on National IPR Awareness Mission, NIPAM 2.0, organized by Bharati Vidyapit's Dr. Patangrao Kadam Mahavidyalaya, IPR Cell, it is my privilege to deliver the vote of thanks on the behalf of organizing committee. First and foremost, I extend our heartfelt gratitude to our guest speaker, Honorable Dr. Niranjan Evles, Scientist Intellectual Property Group, NCL, Innovations, CSIR, NCL, for sharing his valuable insights and expertise with us today. Your knowledge and experiences about IPR have provided us with a wealth of information and inspiration. We are truly honored to have had you, sir, here. May the skills and knowledge we have gained stay with us long after this workshop is over. We are also grateful to Department of Science and Industrial Research, Government of India. Also thankful to the Department of Promotion of Industry and Internal Trade. Also thanks to Indian Patent Office, National Research Development Corporation, Protection of Plant and Varieties, Farmers Rights Authority, New Delhi. Also thank you to National Laboratory Pune for their support. A very special thanks to Government of India as many applications were pending for the organization, but Government of India select our college with a priority. A sincere thank you to all our principal, Honorable Dr. S.D. Foresar, for his guidance and support. I would like to thank you, our Vice Principal, Dr. A.R. Suple, and the convener of this workshop, Dr. B.P. Ballal, for their unflinching support and the coordination. I am very much thankful to the organizing committee, teaching and non-teaching staff of our college for their tireless efforts and support. Our heartfelt thanks to our sponsors and the active participants for their overwhelming response for the workshop as we got the registrations from all the sets. But among them, we got the highest response from the West Bengal. Thanks once again. We are also grateful to our participants, faculty, students, research students, industrial persons for your active engagement and enthusiasm. Our special thanks to Dr. A.M. Deshmukh, President AMI, as he has circulated the invitations beyond boundaries. To the technical support team, Mr. Amul Vande, thank you for ensuring all the arrangements were in place and that everything ran seamlessly. I am
Good.
immensely thankful to the MG Danode for his efforts towards the anchoring of today. Lastly, I would like to thank you everyone who contributed making this workshop memorable and impactful. There is one announcement that separate link for the attendance and feedback will be shared within a short time to your respected mails that will close at 5:30 p.m. today. Only registered attendees will get certificate from Government of India. You are requested to fill it before deadline. In conclusion, thank you all once again for your invaluable contribution and participation. Have a great day. Thank you.
There is one announcement.
Please check your
The
mails.
feedback link has been
Registration
yeah,
link, feedback form has already been circulated.
already
Please
done,
check your
has
mail.
been
Fill up
circulated.
before 5 p.m.
Okay. So you will
Thank you,
receive.
everybody.
Sir, can we end our stream here?
Thank you. Yeah,
Okay. Sir, can we end our stream here?
yeah.
Okay.
Thank you, everybody.